Good afternoon, everybody. Welcome to the latest in our Brody's series of webinars for local government. Today's topic is Brexit for local government lawyers specifically, understanding the law post-Brexit. My name is Charles Livingston. I'm a partner in the Government Regulation and Competition team. For those of you who don't know me, that's my picture, and that's my contact details as well. Just a note of caution for today's session. It is in some respects going to get quite technical from a legal perspective, as it is intended for a legal audience. I think we have some non-lawyers dialing in. You're of course very welcome, but apologies if I lose you on any of the technical points. What are we going to cover today? A few different categories, just a brief explanation of, from a legal perspective more than anything else, what will actually happen on the 31st of January 2020 and what will not happen. What comes next after that? Then, when we'll be getting into the most technical part, how to give the right legal advice to your in-house clients, making sure that you understand and can identify what the law is post-Brexit. We'll then do a little bit on how the law might change with reference to a few areas that are of particular interest to the local government sector, being procurement, state aid and data. And then I'll close with a section on Brexit and devolution and what Brexit might mean for the devolution settlement and for the potential for the Scottish Parliament to gain new powers over matters currently dealt with at EU level. So, what's going to happen at the end of January? So this seems like a long time ago now, but you might remember that the original date for Brexit was the 29th of March 2019. The reason for that was that it fell 2 years after the then Prime Minister Theresa May gave notice to the EU of the UK's intention to leave, and the provisions in Article 50 said that any leaving state would leave on the date agreed in a withdrawal agreement or in the absence of an agreement 2 years after the date it gave notice. But I will not escape your attention that we did not leave on that day. There was a brief extension into April, which we'll call Exit Date 1.1, to allow time to agree a more substantial extension to Exit Date 2.0 on the 31st of October. You'll see that these are 11 p.m. The reason for that is that that is midnight Brussels time, and all the deadlines were being set by reference to Brussels time. So there was an original extension to the 31st of October. That extension was made under, again, Article 50, which allowed for a unanimous extension of the period, but no withdrawal agreement was agreed by then. So we then had another extension. This is the now Prime Minister's letter requesting that extension, making clear that he was doing so under duress, but to Exit Date 3.0, Friday the 31st of January 2020, again 11 p.m. UK time. Now, we do now have a withdrawal agreement between the EU and UK. We had one before. The May government did get a withdrawal agreement with the EU. The problem was they couldn't get that supported by Parliament. The now Prime Minister got changes to the withdrawal agreement, but did not get parliamentary approval for that, at least not on the timetable he wanted it, and we therefore had an election. The result of that election means that the House of Commons now does support the government's withdrawal agreement, so we can expect that to come into effect. So what does that do? Well, it does a number of principal things. It provides for the UK to leave the EU at 11 p.m. Friday the 31st of January, but subject to a status quo transition period until 11 p.m. on the 31st of December, so essentially the rest of 2020. And that transition period means that EU law in almost every respect will continue to apply in the UK as if the UK were still an EU member state. The UK will formally cease to be a member state on the 31st of January, and that means we will no longer have MEPs or a commissioner or judges on the European courts, for example. but EU law, almost in its entirety, subject only to exceptions about things like who can stand to be an MEP, will continue to apply for the rest of the year. The withdrawal agreement allows for that transition to be extended once and once only, and that extension can be for either 1 or 2 years, so it can be to the end of 2021 or to the end of 2022. But the EU and UK would have to agree to extend that before the 1st of July this year. So there will be no more last-minute extensions because the withdrawal agreement does not provide for those. The withdrawal agreement also agrees that EU citizens who are already living in the UK or who arrive in the UK before the end of the transition period can stay in the UK on the same terms and vice versa. The withdrawal agreement, perhaps most famously, makes provision for special arrangements relating to Northern Ireland at the end of transition. I'm not going to spend any time in the details of those, other than to note that those provisions will apply whatever terms are agreed on future trade. So the Northern Ireland position used to be referred to as a backstop, in the sense that that was the arrangements that would apply in respect to Northern Ireland in the absence of a deal. The revised withdrawal agreement has been described as more of a front stop, in the sense that that is pretty much the Northern Ireland question resolved, and it doesn't need to be subject to what happens in any future deals. At least that's the idea. And lastly, the withdrawal agreement deals with the money that the UK is to pay with the EU in respect of various obligations arising during transition, and in respect to more historic obligations as well. The key point that I'm going to pull out of the withdrawal agreement, particularly for local government, who obviously have lots of employees and will have EU national employees who are keen to understand their status. I'm going to pick out the people aspect of it. One point that's just worth noting is that citizens of Ireland are unaffected. Their status is completely unaffected by Brexit, and there is a common travel area between the UK and Ireland that means British citizens can move and live and work freely in the Republic of Ireland and vice versa. That remains in effect, so Brexit has no bearing on that. So any Irish employees who are asking what Brexit means for them, the answer would be nothing. There is no change to their status. In respect of non-Irish EU citizens, the UK, and indeed in respect of UK citizens in the EU, parts of the EU that are not Ireland, the agreement provides that free movement will continue up to the end of the transition period. And in the meantime, the UK will introduce what is called the EU Settlement Scheme. And this is a scheme that's being run by the UK government that provides for EU, but also EEA, meaning Norway, Iceland, Liechtenstein, and Swiss citizens who are resident in the UK before the end of transition. They can apply for what's called settled status, which is a type of permanent leave to remain in the UK, and can in due course lead to British citizenship if the person wants that, or to pre-settled status, which is an interim status that allows people who don't meet the criteria for settled status proper to remain in the UK until we meet the criteria. There is a deadline for applying for settled status of the 30th of June next year. Any EU, EEA or Swiss citizen who is resident in the UK before the end of transition is automatically entitled to one or other of these statuses, but they must apply for them. The statuses are not automatically conferred on anybody. They have to apply. So if you are getting questions from any employees about their ability to remain in the UK, it's very important to make the point that they do have to apply. The difference between settled status and pre-settled status is the person has to have been resident in the UK for 5 years to get settled status. If they don't yet have 5 years by the time they come to apply, they can get pre-settled status until they get to that 5-year cut-off point. There's no fee for an application. The government is at least it says trying to make the process as painless as possible, and it says it is not looking for reasons to refuse anybody settled status. Once we get to the end of transition, and this slide should probably say post-transition rather than post-Brexit, given that Brexit, in terms of leaving the EU, will happen at the end of this month. Post-transition, from the end of 2020, the government is going to introduce a new skills-based immigration system, and that was going to be introduced whether there was a deal or not. The government has said that the system will favour highly skilled and skilled workers and disfavour low-skilled workers. So, for example, have a minimum salary threshold. Low-skilled workers will be able to get a time-limited 12-month visa for temporary short-term workers, but without any sponsorship requirements for EU citizens. So, if as an employer you're in a local authority that has a large requirement for low-skilled labour and you get a lot of that from the EU, you will want to be following along the development of the new immigration system. As things stand, there's no provision for sectoral labour schemes, but there has been discussion of potential exceptions for things like seasonal agricultural work, where there otherwise just isn't a labour force, sufficient labour force available. So that's the withdrawal agreement. The withdrawal agreement bill is currently making its way through Parliament. What does that do? It implements the revised withdrawal agreement in two ways, in that it will give domestic legal effect to its terms, in particular the continued application of EU law within the UK, and it also serves as the process of Parliament approving the ratification of the agreement as an international law matter. So the government can sign treaties, but it needs parliamentary approval to ratify them, and the withdrawal agreement bill will be treated as that approval. In addition to the UK-EU withdrawal agreement, it also implements an agreement reached between the UK and Switzerland and between the UK and the EEA states. It also amends the European Union Withdrawal Act 2018, which we'll come back to make sure that it reflects the terms of the revised withdrawal agreement. So, for example, for the duration of transition, it will repeal the European Communities Act 1972 as of 11 PM on the 31st of January, but will then immediately continue its application until the end of the transition period. It also makes various changes to the Withdrawal Act to allow for the effect of withdrawal, so that the various effects that would have taken place at the point of Brexit instead take place after what's referred to as implementation period completion date, so the end of transition. It also gives the government additional powers to make secondary legislation implementing the withdrawal agreement. You may have seen in the news that it contains a provision that prohibits the UK government from extending the transition period. You'll recall I said that could be done before the 1st of July this year. That is a little bit of political showmanship there, even though the legislation, if passed, will prohibit the government from doing that. A government with a majority of 80 would not have much difficulty repealing that particular provision in order to give itself reinstate the power to extend the transition period. But it's a little bit of political theatre on the basis that the Prime Minister is trying to be as clear as he can be. He has no intention of extending the transition period, and that provision is really just intended to try and emphasise that point to rivals and opponents, both domestic and on the EU side of the negotiating table for the next phase. So what is that next phase? So the Withdrawal Agreement Bill is passed through, or the WAB as it's being called, it's passed through the House of Commons. It's currently in the House of Lords. The Lords may seek to amend parts of it, but will almost certainly not reject it or hold it up. The Withdrawal Agreement is expected to complete its ratification on the EU side soon. Once both sides have finished their processes, it will be ratified and become a binding treaty in international law, and it will then take effect on either 11 PM on the 31st of January or midnight on the 1st of February, depending on which country you're in. And at that point, we will have Brexit. Talks on the future UK-EU relationship will then begin immediately to determine what should happen and what provisions should be in place post-transition. So that will deal with things like tariffs on goods, the ability to provide services cross-border, things like that. Lots of different things will need to be dealt with as part of that. At the end of transition, unless and until there is an agreement on what should happen, then at least some of the no-deal considerations that we've been talking about for the best part of a year, at least, or longer in our case, will become live again. The exception is the issues that have already been dealt with in the withdrawal agreement. So to the extent that the position in Northern Ireland was a particularly concerning element of no deal, that's no longer an issue at the end of transition. But in terms of things like tariffs, then obviously a deal would be needed if those are not to become an issue at the end of transition. So on that basis, worth just recapping the preparations that were being done for a no deal. This image is actually from a few months ago, so there are now more than 884 results on the government's page for all the guidance and regulation it's produced in respect to Brexit. There are ways of filtering those to get to the documents relevant for what you're looking for. But the government produced a lot of guidance and regulation in terms of what it both anticipated doing and thought would happen in the event of a no deal in various areas, various sectors, in respect to various legal matters. So there is an extensive resource available for anybody that wants to try and figure out what might happen at the end of the transition period if the UK and EU do not otherwise reach an agreement on a particular issue. Similarly, the EU had been making preparations, producing what it calls preparedness notices. There are far fewer of them, partly because the Brexit requires the EU to change less than the UK has to change, and partly because the EU was almost going out of its way to not be helpful about what might happen in a no-deal situation and to try to ameliorate the difficulties of that as part of its negotiating strategy. We'll see if that is maintained throughout phase 2. Now that the most high-profile and potentially sticky issues have been resolved in the withdrawal agreement, it might be that there might be more scope for discussing what might happen in particular areas, even if there's no overarching deal. And there are also matters that are the responsibility of member states rather than the EU. So a couple of examples there from Denmark and Germany about preparations that those member states were taking as well, unlikely to be as relevant to local government though. So, if you are an in-house lawyer, you will want to make sure that you're able to give the right legal advice to your internal client departments post-Brexit. So, what does the European Union Withdrawal Act provide for in respect of that? You might recall that that's the act that both provided for the UK to leave, but also sought to deal with the consequences of that, and in particular to make sure that the statute book would continue to function post-Brexit. Because what we didn't particularly want was for the various EU rules in a lot of key areas of law to simply cease to apply with nothing in place to replace them. So the Act introduces the concept of retained EU law as a new category of law. The way the Act is currently drafted, although it will be amended by the WAB, is that retained EU law will be a snapshot of EU law as it stands on exit date. Although once the withdrawal agreement and transition is in place, the WAB will provide for that snapshot to be taken at the end of transition. That essentially means that whatever EU law is at 11 PM on the 31st of December, that body of law will continue to apply in the UK. The Act does allow for amendments, prospective amendments, to be made to that body of law to ensure that on exit day or at the end of transition, the law makes sense and it can be applied sensibly, notwithstanding that the UK is no longer a member of the EU, and you'll see some changes that are proposed in a couple of areas as we go through the slides. But essentially it means that if an enforcement responsibility was on the European Commission, then that enforcement responsibility will be transferred to a UK body. If notices had to be published in the official journal of the European Union, the UK government, or indeed the Scottish government, if it's their responsibility, will specify some other publication in which they should appear. Things that require reciprocity with the EU that might not transpire post-Brexit, or that simply don't work for a non-member state, that there are a number of orders in place that prospectively amend EU law so that it would function post-Brexit. Going forward then, that means that there will be European EU law and British EU law. The two will be identical at the end of the transition period, but over time they will diverge as the EU changes things that don't apply to Britain, and the UK makes changes that do not apply in the rest of the EU. And in due course, and we'll come on to this, where EU law touches on devolved responsibilities, you may have European EU law, British EU law, or English EU law, Scottish, Welsh, Northern Irish EU law. So there will be different branches of EU law, and it will be important to make sure you understand that process so you can identify the correct law that applies to you at the end of transition. So if you are considering or advising on an area that's affected by EU law, particularly if the advice you're giving has a potential life beyond the time horizon of the transition agreement, it's important to check whether that law will be or potentially has already been affected by Brexit. So how do you identify the law post-transition? European Union Withdrawal Act is a pretty complicated, or at the very least, lengthy piece of legislation. There are some particular categories of law that it's important to be aware of. One category it refers to is EU-derived domestic legislation. So what that principally, but not exclusively, means is legislation that implements EU directives. So to give you one example that we will be coming back to, the Public Contracts Scotland regulations implement the EU Procurement Directive. Those regulations are made under the European Communities Act 1972, which you will recall is to be repealed at the point of Brexit. It will be saved during transition, but then it will fall away after that. The usual rule is that if you repeal a piece of primary legislation, all the secondary legislation made under it will also be repealed. So what the Withdrawal Act does is it provides for all of the UK legislation, whether made under the 1972 Act or otherwise, where it implements EU law, that will survive the repeal of the 1972 Act. That body of law will also be subject to the principles that are set out later in the Act, which we'll come on to a couple of bullets' time. The other principal category from a legislative perspective is the concept of direct EU legislation. And what we're principally talking about there, although again not exclusively, are EU regulations. Now, EU-level regulations are distinct from directives in that directives say what a member state has to implement in its own domestic law, and the member states then go off and do that. Regulations don't require any implementation at UK level. They simply come into effect and then apply directly. The best known example of an EU regulation is the General Data Protection Regulation, GDPR, which everyone will be familiar with. Now its most famous example is not necessarily the best because it was a little bit of a hybrid in that the parts of it needed to be implemented domestically. So the Data Protection Act 2018 does that. But there are lots and lots of EU regulations that simply exist only at EU law level, and there is nothing in UK law that implements them. So what the Withdrawal Act does is it says that those regulations will continue to apply, notwithstanding that the UK will have ceased to be a member of the EU. The Withdrawal Act then provides for a saving of all rights, powers, liabilities, obligations, etc., that you can see in that bullet point, notwithstanding the UK's departure from the EU. What that means at its most basic is that if a local authority or the Scottish Government or the UK Government does something that is contrary to EU law prior to Brexit, and that gives rise to a claim against them for damages, for example, that right to damages will survive Brexit. So if somebody could have raised a claim or relied on any powers in advance of Brexit or the end of transition, then they'll be able to do so afterwards as well. The Act makes particular provision for the concept of supremacy of EU law, and where this matters is if you are looking at two different pieces of legislation and they are in conflict. The usual position under the UK Constitution is that if you have two pieces of legislation and they are in conflict with each other, then the later piece of legislation takes precedence on the basis that Parliament or the Scottish Parliament or whoever passed the legislation intended to repeal the earlier legislation to the extent it was inconsistent. EU law, however, if a piece of UK legislation is contradictory to a piece of EU law, then the EU law takes precedence regardless of whether it was passed before or after the UK legislation. And the Withdrawal Act provides for that principle to continue in respect of any UK laws passed prior to the point of Brexit. So if you have an Act of Parliament that's passed a week before the end of the transition period, and it is contrary to an EU law requirement from 10 years prior to that, that EU law will still take precedence. So any case over which piece of law should take precedence, even if it's brought after Brexit, the supremacy of the EU law principle will still apply and the EU law provision would take precedence. That will all change at the end of the transition period because, as is kind of the point of Brexit, at that point the UK Parliament or the Scottish Parliament or whoever is responsible will have the ability to depart from EU law, to amend it or to legislate contrary to what it said. So the principle of the supremacy of EU law will survive Brexit to that extent in terms of being backwards looking, but it will not apply to legislation passed after Brexit. The interpretation question, there's a section in the Withdrawal Act that deals with how UK courts should interpret questions of retained EU law. So if they're interpreting either direct EU legislation or EU-derived domestic legislation, then the Act provides that decisions of the Court of Justice of the European Union in respect of that EU law will remain binding on all UK courts except the Supreme Court and the High Court Justiciary when there is no appeal to the Supreme Court. So if the highest court in the land for that particular matter is looking at it, it will be able to depart from Court of Justice precedent in the same way that it's able to depart from its own precedent. I've noted in the bullet that that's to be revised by the WAB. So the WAB includes a provision for the government to specify by regulations circumstances in which courts other than the Supreme Court and the High Court Justiciary will be able to depart from pre-Brexit EU law. There's no indication yet of how and when that might be used. It's the sort of thing the House of Lords might take exception to and want to be amended. But as things stand, there is the possibility for other courts and indeed tribunals to be given the power to depart from EU case law in certain circumstances. The Withdrawal Act then contains what described as fixing powers. I mentioned earlier that it wants to make sure that any piece of EU legislation that wouldn't work in a post-Brexit environment can be fixed. The Act gives powers to do so to the UK government, and in areas where it's responsible, the Scottish government, to do so by making regulations. And those are very wide powers, and there are lots and lots of statutory instruments that have been made under the Act. So how to find the law, how to understand what the law will be post-Brexit? I mentioned the statutory instruments. There are over 1,000 made by the UK government. There are also some Scottish statutory instruments made by the Scottish government. There are only around 40 of those, I think. So if you want to check whether a piece of EU law or a piece of UK legislation is going to be amended as a result of Brexit, you could try and work that out from the statutory instruments. It would be difficult though, they're very detailed, and they are amending provisions, so they don't restate the law in its new form. You would need to track through each change in the language. If you have access to something like Westlaw, then those sites are doing that work for you. So on Westlaw, if you go onto a particular piece of UK law or in the EU law, if it's on Westlaw, you will see how many versions there are or have been of that. Ordinarily, you would see, for example, version 4 of 4, and you'd be able to scroll back through the previous versions to understand what the law was on a particular date. If you open up a piece of legislation and it now says version, for example, 4 of 5, that says that there are amendments that are intended to be made to that provision but are not yet in effect, and a lot of those amendments will be Brexit related. So you are able to click forward to see what the post-Brexit version of the legislation will be. I don't want to turn that into too much of an advert for Westlaw. I'm sure other services are doing something similar, but Westlaw is what we use. So there are tools available to work out what the law is going to be as a result of Brexit. One word of caution on the statutory instruments is that they are subject to change. They were all produced on the premise that they needed to be in place for a no-deal scenario, if that was to come about. There will be a number of them that will still be relevant at the end of the transition period, particularly if an issue has not already been resolved in the withdrawal agreement. But in the event that there is an agreement or multiple agreements between the UK and EU about what should happen post-transition, then certainly some, if not, some but not all of those statutory instruments will be amended to make sure that they are consistent with whatever it is that has been agreed. So it is a bit of a moving picture, but if you're advising on the law at any one point in time, hopefully you'll have an understanding of where to find that and how to do that. So to give you some examples of how the law might change, examples selected because they dovetail fairly neatly between my practice and things relevant to local government, but that nevertheless illustrate a lot of the issues that need to be navigated in this respect. Taking procurement as our first example. So the Scottish Government has made the Public Procurement, etc. Scotland Amendment EU Exit Regulations 2019. I should say, if you're looking for Brexit-related statutory instruments, they almost all contain the words EU Exit. So these have been made by the Scottish Government. They make various provisional amendments to the Public Contract Scotland regulations, and indeed there are also changes to the concessions and utilities regulations that are intended to make the procurement rules work in a post-Brexit environment. Even in respect of these statutory instruments, the position is quite fluid, so these have been amended twice, despite only being made last year. The most recent amendment was to update the monetary thresholds that apply and the OJU thresholds that apply to EU procurement. So they are in a bit of a state of flux and will no doubt continue, if not these, then other statutory instruments will continue to be amended between now and the end of transition. The UK government has made equivalent UK regulations, so this is an example where, because the Scottish government made the current procurement regulations, it was the Scottish government that provided for how those should be amended in the event of Brexit. And the UK procurement regulations are subject to amendment by an equivalent set of UK exit regulations. In both cases, they are examples of mostly technical changes, so removing references to the Commission, to the Official Journal of the European Union, etc. They are also a good example of a coordinated UK and Scottish approach to amending the procurement rules. And I have to say that generally where the Scottish Government has been making these regulations, at least where they're of a sort of a technical nature to make sure the law functions, it does seem that the different governments have been working fairly well in coordinating and harmonising their approach on those. There is also, and we'll come back to this, a draft concordat between the UK and the Scottish governments on how the procurement rules should be modified or not modified in future, particularly focusing on the UK's international obligations and making sure those are given effect to. So these regulations were prepared for no-deal purposes, but their application was then suspended until the end of transition. They may therefore be subject to further change between now and transition, particularly if, for example, the agreement or an agreement reached between the UK and the EU made particular provision for the UK to continue to apply the EU's procurement rules, or at the very least to give EU businesses the same access to public contracts as UK businesses have. On that question, as it stands, the Scottish Government's guidance says that nothing fundamental will change, so things like the financial threshold and the basic requirements of procurement will stay the same. But procurement notices will have to be published on a new UK e-notification service rather than in ODU. Scottish authorities will also still need to publish on the Public Contracts Scotland website, so I'm afraid that element of duplication will not go away. It remains to be seen how this e-notification service will work and the relationship between it and PCS. There is likely to be a new type of single procurement document. So for those of you who know procurement, at the moment there is the European single procurement document. That concept will be retained, but it will become a different document. It will no longer be using the European one. Possibly there might be a separate Scottish SPD. That would seem duplicative and kind of defeating the point of having an SPD, but it may nevertheless happen. Requirements of certificates and evidence through the e-Certis system will no longer be required because that is an EU system. More substantively, the obligations that are owed to economic operators from the EU and EEA at present, that will be narrowed under the regulations to be only economic operators from the UK and Gibraltar. But that is subject to the comment that the UK intends to join the WTO's government procurement agreement, and the regulations, the exit regulations, provide that the procurement obligations will be owed to all economic operators from all signatories of the GPA, and that includes all EU member states. That will be the case if the UK has joined the GPA by the end of transition. Even if the UK has not joined the GPA, if the UK and the Scottish public authorities will still have to treat economic operators from GPA signatories in the same way that they treat UK businesses for 18 months after transition. So it's essentially giving the UK 18 months to join the GPA, during which it will act as if it has already done so. But if it has not joined by the end of 18 months, then the duties will be limited, so they only apply to UK and Gibraltar operators. Originally, that was an 8-month period, but it was thought that that was maybe a bit ambitious, or maybe didn't allow enough leeway for the UK to join the GPA, so that was extended. For contracts that are below the GPA financial threshold, which is the same as the ODU threshold, in other words, contracts that are covered under the Procurement Scotland Act 2014, Procurement Reform Scotland Act 2014, authorities will only owe obligations to economic operators from UK Gibraltar, and that's regardless of the GPA status. So that will change. The 2014 Act is certainly, it's not been the subject of much litigation, but public authorities will be having to navigate it. So it's worth noting that at the end of transition, unless something else is agreed, that the obligations in that Act will be narrowed down to UK and Gibraltar businesses only. Next, Brexit and state aid. Now, the regulations in respect of state aid, these are UK regulations, there are no Scottish equivalents. These are draft only, they have not actually been made, and they do potentially remain subject to change. They remain particularly vulnerable to change, I think, more so than other regulations, because they're draft, but also for policy reasons I'll come on to. So they say that the state aid rules will be maintained even in a no-deal scenario, so they were produced prior to no deal. For our purposes, what we're talking about there is even if we get to the end of transition without a deal, these regulations would provide for the EU state aid rules to continue to apply within the UK, meaning that things like the EU's block exemptions will remain applicable, pre-Brexit Commission approvals will remain valid. There would be a significant change in terms of the enforcement body, so the Competition and Markets Authority, which is a UK body that currently deals with antitrust and merger control, would take over the Commission's role in respect of state aid, so it would deal with notifications, approvals, investigations, etc. And the intention there is for the CMA's procedures to be kept as similar to the Commission procedures as possible to limit the amount of disruption. The changes are to take effect at the end of the transition period unless otherwise agreed, and this state aid might be a bit of a sticking point. The EU might push quite hard for the UK to continue to adopt its rules. Curiously, even though these regulations provide for the rules to be continued even in the absence of an agreement with the EU, the text continues to require an effect on trade between the UK and the EU. So the test is not narrowed to catch aid that would affect trade between, for example, Scotland and England, but wouldn't affect trade between the UK and EU. It remains at that very high level of UK-EU trade, which is curious when you consider that the premise is that these regulations would apply even if there was no trade agreement between the UK and EU. But I think they've been drafted that way in order to try and hew as close to the status quo as possible. This will be an issue of particular relevance to local authorities. At the moment, there is a member state obligation to publish aid granted under the General Block Exemption Regulation on a website. The draft regulations provide for that requirement to be pushed down to the individual aid grantors. So, for example, each local authority would have to publish on its own website all aid it granted under the General Block Exemption Regulation, which is potentially a fairly onerous administrative burden and a new one. So I mentioned there's no separate Scottish regime, but there are some points worth noting in respect of Scotland. The CMA, under the regulations, would not have the power to take enforcement action against aid required by UK Acts of Parliament. The Commission does have that power for the reason we discussed about the supremacy of EU law, but within the UK Constitution, something that's provided for by an Act of Parliament cannot otherwise be overridden by a government agency, which the CMA is, even if it's acting under an earlier Act of Parliament. So that's the constitutional principle there. However, Acts of the Scottish Parliament don't have the same supremacy in the UK Constitution, so the CMA would have the ability to suspend or even terminate aid that was mandated by Acts of the Scottish Parliament. The CMA would, of course, have the power to take action against aid where the UK government had issued it as a discretionary matter, and similarly with the Scottish government where it had the discretion over whether to grant aid or not. The CMA's guidance says that Scottish devolved bodies should engage with the CMA via the Scottish Government's state aid unit, so continuing the current reporting process. COSLA are lobbying for a simpler set of state aid rules and for consultation with local government before the UK government agrees to any stricter rules in any trade deals. And indeed, the UK government, or in particular the Prime Minister, hinted during the election that he may not be willing to continue to follow the EU state aid regime, at least not in all of its fairly strict aspects post-transition. Possibly that's a negotiating position, and that will change in the course of the trade talks. But as things stand, the draft regulations may or may not be introduced in their present form. But I think, at the very least, the CMA is likely to take on that responsibility. So there is a fair amount of value to be taken from understanding what the draft regulations provide, even though they are probably subject to change. Briefly on data protection and GDPR, there's a high level of uncertainty about what will happen between the UK and EU in respect of data protection. At the end of transition, the UK will become a third country in the EU parlance, meaning it's no longer part of the EU's safe zone for the transfer of data under GDPR rules. Now, the transfer of data between the EU and UK, local authorities will have an interest in that, but less so than some businesses. But the key point for local government purposes is really, is GDPR going to continue to apply, and are you still going to have to comply with it? The answer is quite possibly yes, because in order to get permission for the transfer of data with the EU, which I think the UK will definitely want, and UK business will definitely want, the Commission has to approve that. The Commission has to approve the UK as a third country is suitable to have data transferred back and forth to it, as for example Israel has been approved. It should be possible to do that during transition. The Commission would not engage on that subject prior to the UK actually leaving the EU, but it should be legally possible to have those discussions during transition. Whether an 11-month transition will be long enough remains to be seen, but if the Commission is going to approve that, it may well be that that will be conditional on the UK committing to retain GDPR. So if you're hoping that Brexit is going to relieve local government of the fairly onerous responsibilities that GDPR places on you, I would not bet on that coming about, I'm afraid. So finally, on Brexit and devolution, there is a question of things that are currently dealt with by the EU. Brexit will return those competences to the UK, but to what extent will they then move down or on to the Scottish Parliament and Scottish Government? A very quick recap on how legislative competence works in Scotland. Scottish Parliament and Scottish Government have their powers limited by reference to various things, including that they cannot lawfully legislate contrary to EU law or do anything prohibited by EU law, and they also cannot lawfully legislate in relation to reserved matters. And where Brexit creates interesting issues and indeed friction is in the relationship between those two things. So reserved matters include things like big picture items like the Constitution, political parties, foreign affairs, defence. The Scotland Act also sets out a number of more detailed specific reservations, for example, fiscal, economic and monetary policy, currency, financial services, financial markets, money laundering. These are all reserved to the UK Parliament, and so the Scottish Parliament does not have power over them, except within that category, local taxes. So, for example, that's why the Scottish Parliament and the Scottish Government have responsibility for council tax. Within trade and industry, there are issues there like consumer protection, where local government has a role to play, but that is reserved to the UK Parliament, and the Scottish Parliament does not have a role in relation to those. Where Brexit complicates things is that there are various matters that are dealt with at EU level, but are not reserved to Westminster, or are only partly reserved to Westminster. So matters like that are the responsibility of the Scottish Parliament and the Scottish Government, and in many cases also the other devolved institutions, although the scope of devolution in each country is not identical. In some cases, it is only a notional responsibility though. So where EU requirements are very significantly harmonised, as they are in agriculture, for example, member states do not have that much room for manoeuvre. So the fact that delivery of agricultural subsidies, for example, is the responsibility of the Scottish Parliament and the Scottish Government, they don't really have a lot of leeway in respect of agricultural policy itself, because that tends to be set at EU level and then applies equally to all member states. As a result, it then produces the same level of harmonisation within the UK, because the UK government and the Scottish government are subject to the same restrictions, so they can't do things differently. However, because those areas are not reserved, and I think that's probably because the Scotland Act assumed that the UK would always be a member of the EU, and so left the EU law restrictions to do a lot of the heavy lifting. But because these issues are not reserved, the default position would be that once the EU law restriction falls away, the devolved institutions will find their competence in those areas becoming unrestricted. The current limitations on them will fly off. And the concern in respect of that is that any divergence within the UK in key areas might create barriers to trade moving around the UK and disrupt the quote-unquote UK single market, which is a term that's kind of been developed in order to discuss this concept, but the concept itself has been kicking around since the Act of Union, which required there to be no barriers to trade within the UK. There are, so the various governments have done the exercise of identifying issues that are either not reserved or are only partly reserved, and where the EU has competence, and they've divided them into a number of categories. The first category is that no further action is required. So the UK government in particular is content that if there is divergence in these areas, that is not seen as a particularly significant problem or risk from a UK single market perspective. And I've given you some examples there, including some that are going to be relevant, particularly relevant to local government, like consumer law, harbour law, environmental impact assessments. Some of these are possibly surprising. You might think, do you really want different rules on aviation? But in some respects, areas are mostly or partly reserved with only limited exceptions. So in respect of aviation, there's no need for particularly strict controls on what the Scottish Parliament might do in respect of aviation, because the Scottish Parliament's powers in respect of aviation are very, very limited. Then the middle category is where divergence is a potential problem or risk that should be manageable without requiring legislative restrictions. We've got this concept of non-legislative common frameworks might be required, concordats and things like that. It's a word I mentioned earlier in respect of public procurement. So you can see some examples in this category on this slide. The yellow highlighting contained use of GMOs, that's highlighted because that was previously in this category of no further action required. Presumably in discussions somebody has thought it is more of an issue than they originally thought, so it has been moved up. The green highlighting for nutrition claims in respect of food and for public procurement show that those have been moved down. They were in the category where it was thought that legislative restrictions would be required. They've since been moved down into the non-legislative category. So you can see a number of things there that are likely to be relevant to local government, including things relating to planning. We've already covered procurement in a fair amount of detail. Then we have the highest risk category where it is thought that legislative common frameworks might be needed in whole or in part to restrict by statute the room for each part of the UK to take a different approach from the other parts. So the subjects in this category have been identified where divergence would be a significant problem or risk, and so legislative restrictions might be necessary to ensure consistency. And you can see a few in there that are going to be relevant, potentially relevant to local government, in particular waste packaging and product regulations, which can be relevant to local government's waste obligations. Similarly, things like food labelling, where it might be a trading standards obligation. So these have been identified as the highest risk areas from a divergence perspective. So there's then a separate category where issues have been identified as requiring further discussion on whether or not they are reserved. So that means the governments disagree on whether the devolved institutions would have power in these areas in the absence of an EU law restriction. And those have been whittled down to 4 areas, which you can see on there. They include state aid, very relevant to you guys. There were previously other things on the list, like medical devices and vehicle standards, but those have been taken off, which presumably indicates that the devolved institutions have accepted that these are reserved matters and they don't have a locus. In terms of how to deal with the possibility of divergence, the Withdrawal Act provides in Section 12 that responsibility will pass by default to devolved institutions, but it does give UK ministers the power to freeze their ability to legislate in a specific area so that divergence does not happen before legislative common frameworks can be agreed. So such an order would limit the devolved body to do only those things it could have done pre-Brexit in the relevant area. So for example, I mentioned earlier, the Scottish ministers have the responsibility of facilitating agricultural payments. So even if a freezing order was made in respect of agriculture, they would still have that responsibility. The UK government gave a political commitment to preserve the equivalent status quo in England in these areas pending agreement on frameworks. It couldn't impose an obligation on itself not to do things because Parliament cannot bind itself, but it can bind the devolved institutions. There's an obligation on UK ministers to consult its devolved counterparts and report every 3 months on where and why they've made any freezing orders and on the progress made towards UK-wide frameworks. Which brings us on to our final slide. The Welsh Assembly consented to this freezing order power, but the Scottish Parliament did not. You might recall the stramash over that when the Withdrawal Act was nevertheless passed by Parliament in 2018. First time a piece of legislation had been passed over Scottish Parliament objections. The freezing power has not yet been used by UK ministers, but that may be because it's not a live issue until divergent legislation becomes possible, which doesn't happen until the end of transition. There is substantial work going on in relation to the development of frameworks at official level, but so far only limited agreement has been reached. So there are quarterly reports coming out that are reporting on what's being discussed and what, if anything, is being agreed. There is a draft concordat on procurement, which I mentioned earlier, but only one area has had a framework agreement actually developed in the sense of getting past the policy development stage and into the review and consultation stage. That's in respect of hazardous substances for planning. In order to move on to the next stage, political agreement will be required, and so far no discussions in respect of these areas have got to the stage where the politicians have actually agreed on what should happen. There are likely to be key stress points ahead on this. The agriculture and fisheries bills that were in the UK Parliament prior to the election were on their way towards confrontations between the government and indeed the Parliament, because the Scottish Government was not happy about what was proposed in those. So those may come up again. The Scottish Government in particular rejects the concept of a UK single market, so is not particularly enthusiastic about this process at all, and has indeed said that if any freezing orders are made, it will withdraw cooperation on Brexit matters. So there may yet be scope for pretty significant political disagreements in respect of that. If you want more information on Brexit, our Brexit hub, just Google Brodie's Brexit, you'll find lots and lots of information on there. You might need to Google a little bit further to whittle it down to the areas you're interested in, because we do have dozens, if not hundreds, of pieces on a number of various issues, but that's certainly a valuable resource. And if you have any queries, then a lot of you will know Christine O'Neill. Christine and I head up our Brexit advisory group, so we are your best first points of contact on any Brexit matters. We're supported by Hannah Fram, practice development lawyer, who has particular responsibility for and expertise in Brexit matters. So if you have any further queries, please feel free to get in touch with those. Questions, I've run slightly longer than anticipated, but I've got time for one question, I think. The question relates to citizens' rights to remain in the UK. Says that they have to arrive before transition date, so how does that work with 5 years residence? What if a UK citizen arrived in Germany a week before the transition date? As long as the UK citizen was arriving there and then residing there for however long was left between then and transition, they would be eligible to stay on a permanent basis. They would need to be there for 5 years in order to get settled status, but in the meantime, they could get pre-settled status. So I'm using the UK terms, but the equivalent position in Germany. So they would be entitled to stay while they built up that 5-year period. And that works vice versa as well. A German arriving in the UK just before the end of transition can then stay for 5 years with pre-settled status, and at the end of that 5 years get settled status, and then if they want, move on to citizenship and potentially other immigration statuses as well. I have run a couple of minutes long, for which I apologise. We don't have any slides on the next webinars in our local government series, because the spring series is under development at the moment. You will get an email asking you for feedback on today's webinar. If you have any suggestions on topics you would like us to cover in a future webinar, please feel free to reply with those. If you need confirmation of CPD time, this webinar is eligible for CPD, so if you need a certificate of attendance, there will be details on the email that's coming out to you that will tell you how to go about getting that. So we would be grateful if you would provide feedback when you get that email, because it is very valuable to us, and we do appreciate you taking the time to give us your views, and indeed I appreciate you taking the time to dial in and listen in today. So if there are any queries that come up later, please do feel free to get in touch. Otherwise, we will hopefully digitally see you at another one of our webinars in future. Thank you.